Hello everyone, welcome to the new video on 3-minute series for prelims. In this video, we'll be discussing about the Forest Rights Act of 2006. Since many years, some of the forest-dwelling communities like the scheduled tribes have been living in symbiotic relationship with the forest, where they have been helping in the conservation of the wildlife and also the conservation of the forest as well. But there has not been a legal relationship recognized by any government so far. The worst happened in the time of British rule, where these communities have been evicted from the land. Therefore, the Forest Rights Act of 2006, it seeks to recognize the forest rights who are dwelling in the forest communities, like the scheduled tribes and the other traditional forest dwellers. The Act recognizes 4 types of rights, that is title rights. If a family is cultivating a piece of land in a forest, that is to be given a title right, and the maximum area is the 4 hectares. And other is the use rights, where the family, that is forest dwelling scheduled tribe or the other forest dweller communities, can extract minor forest produce and sell them in the market. The examples for minor forest produce is bamboo, latex, honey, etc. The other rights are the relief and development rights. If a forest-dwelling community have been evicted illegally or forced displacement due to the construction of a dam or etc., they need to be rehabilitated and then evicted from the land. The last right is the forest management rights, which recognizes the community forest resource, where a community as a whole develops a piece of land in the forest area. The eligibility criteria to get a forest right or other title rights for a member or a community is the family's ancestors should be living in that area for the past 3 generations or 75 years prior to the act, that is 2005 year. The procedure for granting title rights starts with the Gram Sabha, where they initiate an application and it is screened at the Taluk level committee and then goes to the district level committee, where finally the title rights or the community rights of a group of community are awarded. If a land or a title right is recognized in a particular family, it cannot be sold or transferred to another person. Now we'll discuss what are critical wildlife habitats. They are the areas under the national parks and the wildlife sanctuaries which should be kept free for wildlife conservation. This has been dealt explicitly in the Forest Rights Act, as the Forest Rights Act seeks to give forest rights to the community, while the critical wildlife habitat seeks to evict the people from the areas. The declaration of the critical wildlife habitat has to happen with the consent of the Gram Sabha, and the process goes like this. The recommendation has to go from the state government regarding the areas that were to be declared as critical wildlife habitat, and finally it will be declared by the Ministry of Environment in the Gazette notification. Let us solve this question. Consider the following statements. The definition of critical wildlife habitat is incorporated in the FRA 2006. For the first time in India, Baigas have been given habitat rights. Union Ministry of Environment, Forest and Climate Change officially declares and decides habitat rights for primitive and vulnerable tribal groups in any part of India. The correct answer is A. As we have discussed, it is not the Ministry of Environment and rather it is the district committee in each district which gives the title rights.